Was President Obama's executive order on immigration legal? The Justice Department's Office of Legal Counsel says so. My next guest says maybe not. Baker Hostetler partner David Rivkin has an op-ed in this morning's newspaper authored with Elizabeth Foley, and he joins us now. David, isn't Justice's Office of Legal Counsel the final say?
It is an office with tremendous degree of credibility, nonpartisan, and a tradition of excellence. I think they substantially diminished those assets. That's a very, very poorly written opinion. I would say probably the worst OC opinion I've seen, and I'm familiar pretty much with most OC opinions that have come out over years.
Well, that's a big call, the worst opinion you've seen. David, what were the main problems with it in your view?
Well, there are several substantive problems and several stylistic problems. Stylistically, it does not even read as an OC opinion. It does not mention any other OC jurisprudence. It makes a couple of points that are totally extraneous, wrong points, by the way, to the legal questions that are being asked to answer. And their point is that basically Congress cannot stop this by putting an appropriation rider in place because ICE, the entity implementing this, is self-financing, and second, there would be no judicial review. Both of the points are highly debatable, but these are policy points, they're political points, nothing to do with legality. This reads like a hastily thrown together legal brief.
So, David, is the problem that the president's executive order affects millions of people? So, in other words, it kind of makes new law, that it's not a narrowly defined exception. Is that one of the issues?
It is one of the issues, but let me say, first of all, that there are really three biggest problems, as we mentioned in our piece. One, this is not an exercise of case-by-case discretion. This is a wholesale exemption from the law of large categories of people, which even OOC admits would be unconstitutional, but they pretend that this is case-by-case exercise because there is some discretion available to a few dozen ICE officials, the DHS officials, are going to process over 4 million applications. To give you one example, in the administration's previous program, very similar to this, albeit smaller, for so-called dreamers, out of 500,000 plus applications submitted, fewer than 3% were rejected. Anything that you get 97% approval is a rubber stamp. But more importantly than that, even if it's case-by-case determination, this exceeds the normal prosecutorial discretion that the president has, because this is much more than the decision not to prosecute. This is a decision to bestow a boon, a benefit, work authorization, and other benefits. And importantly, Congress has never given the president authority to do that.
Well, the president says otherwise. He defended it this Sunday on Stephanopoulos on ABC. David, do you think a legal challenge then would succeed?
I'm pretty optimistic that the legal challenge, most likely by the states, would succeed. It costs money, Mary, for the states as a result of this, additional resources. But more importantly than that, it's very important, it is really an affront of the sovereign dignity of the states. Let me briefly explain why.
David, unfortunately, we're out of time, so we're going to have to leave that for the next segment. But we'll have you on again soon. Baker Hostetler partner David Rivkin, thanks so much.